So it's a pleasure to be here, to speak to you. It's very nice that colleagues from Vilnius University arranged that conference, and that we have lots of distinguished guests coming here to discuss about very interesting topics, legal topics, about potential, that might potentially influence change of concepts and some other aspects. Let me start with waking you up a little bit. I would like to ask you to vote. Here's a question. Should emergence of digital assets transform application of law? Yes. So who is in favor of that? Please raise your hand. Okay. Against? Sustained? So I agree with majority and we can finish. But if you allow me, let me elaborate on this a little bit. Yeah, digital assets are very interesting animals. As was already presented, the problematics of it within the first panel. So I also agree with this remarks, and let me add to this a little bit. So first of all, what traits, what characteristics of digital assets that show that certain different conceptualization or different putting in different shelves would be necessary, and maybe some other legal remedies shall be applied in order to regulate and standardize relationship of humans towards the digital assets. So first of all, it's concept and taxonomy. About the concept, the last speaker, Professor Earp, very nicely put it to you that the concept is very fluid, and it's truly difficult to conceptualize and include all this realm of digital assets into the old concepts, the classical concepts. And this discussion in relation to the concept of this digital asset, most probably it will continue. It's not so straightforward. For example, can data be owned as an asset as such, if we describe digital asset in a broader sense, yes? As something digital and something having proprietary or some other benefit or some other value, yes, in a broader sense. And the answer can be yes, or the answer can be no, or something in between, maybe, yeah? If you already look at the forthcoming standards or legal provisions, such as, for example, UNIDROIT principles on digital assets and private law, in that particular principles, the draft of the principles told not all the data, not all the digital records can be considered as digital assets, only those ones who are capable of subject of control. And what is subject of control? So that's new phenomena evolving and new features evolving. Subject of control, if somebody who has this control could reap all the benefits of this digital records, could preclude the other parties of doing this, could transfer this, yes, and it is possible to identify that somebody has the benefits, so somebody has a private key, or somebody has other means of control. So this leads to the conclusion of that particular drafters that inscriptions in social media, they are not digital assets. And this is also provided an explanatory memorandum to that particular source of soft law. And this gives you a difficulty. So there might be a different types of regulation of different digital records, yes. And most probably we will see that, differences or different features of various digital assets might be regulated in different ways. And taxonomy of digital assets is also very important and might be very important. We have cryptocurrencies, we have variety of tokens, fungible, non-fungible tokens, yes. Is, for example, money in gaming, such as coins in video games, digital asset or not? Yeah, it might have certain value. It is also expressed in data records, yes. But most probably, if you read the license agreement, which you subscribe to, then logging into the game, that will tell no, it's not an asset, but we have some court precedents telling no, that might be considered as an asset, and even in some court precedents in the United States, we already ordered to compensate loss of this type of money in the same, well, value in the same format, giving back the same amount of these coins, game coins, to the suffered party, which is very interesting, and that's very interesting development. So we might see that, well, different sorts of digital assets with different concepts could also influence, well, difficulties in trying to put them into the specific shelves and then try to apply specific rules, yes? And we had very interesting discussion with students this week about that type of precedents awarding compensation in game coins, yes? How to enforce it, yeah? So can you imagine that you have a judgment with execution title, some documents with execution title, go to a bailiff or enforcement officer, and what did he or she do? Yes? It is possible to do anything or not. Does a bailiff or enforcement officer have some code to override the game code, telling, yes, I'm now, well, withdrawing this amount of money from this person's account and putting it in a different person's account? Yeah? Another point also can be shown in that particular example is decentralized and global environment. Yes, so many of digital assets, they live not in one country, they might be located in multiple servers. Then we talk about blockchain or ledger technologies, they're distributed, yes? And how to collect them in one place, in one jurisdiction, in one piece, yes? Where to go if you want, well, some redress, some compensation. For example, in this situation with games, should I go to the location of the, well, manufacturer of a game or provider of a game in my particular, well, location? And should I go to the location of my counterparty in the game which stole my coins, yes? Or should I apply to my own courts in my location? There might be 4 options available or even more, yeah? So how to solve it? And this is only the start of the story, which might be very interesting. Another point is virtual nature, which was already described by the previous speakers. So they do not have something, well, tangible. You cannot touch it. Maybe you can see it if you project them on the screen or in some different, by some different medias, etc. But they are not expressed as a thing, and that is also posing certain well, issues towards how to regulate it and how to tackle it, how to shape it, how to segregate it from anything else. Yeah. Another also interesting trait or feature is that they are technology-based and operated. And these technologies, they differ. Yes. They even evolve. If you talk about blockchain, they might evolve in the coming years. And if you have the same technology now, in 5 years, it might be a little bit different or maybe totally different technology, operating on totally different code with absolutely different architecture and logics. And when you talk about this interplay of the technology and the law, you have another very big problem. What is governing? What has priority? That a code has priority as a source of regulation of activities, or whether it's a law, yes? For example, you as a judge, you can direct to do something, but if code does not provide of doing this, well, no enforcement. It's not possible. And the code itself, it regulates. And maybe you've heard about this big discussion that the code becomes a law, because it becomes a source of law. With digital assets, you have the, well, this specific situation, which also everybody has to be aware of. And another point, in many types of digital assets, you have an anonymity of control issue, anonymity of control problem, yes? So linking of person, of specific person who might, well, claim the benefit of a particular, well, record, digital record, might be problematic. It might be obvious, or it might be concealed, purposefully concealed. And that might also raise specific issues such as AML concerns, yes. And these particular, well, traits, they lead, and not only these ones, but there are more, yes. They lead to the notion that it is not only the private law, the civil law, which might be revised. There are lots of fields of law that might need some adjustments. I will talk about what type of adjustments can be done, but conflict of law issues related to digital assets may arise, jurisdictional issues, code versus law, to what extent who rules what, yes? What particular, well, phenomena rules what, and maybe code can be, well, made a part of the law and can be regarded as extension of the law. If somebody agrees, or if, well, sovereign, the government will tell, we will extend application of the same, well, notion of the law to the particular set of code, yes? That might be interesting, and we might expect of that type of interaction between these two phenomena. Cybersecurity issues also very pertinent to these digital assets. And, well, they might be stolen, yes. Somebody breaching, well, your proprietary or any other rights may, well, delete your information or do something else, steal this, yes, take it, or replicate it, well, duplicate it, or well, issue multiple copies of it, and you lose your value, yeah? And there are other issues as well, such as consumer protection, ML, intellectual property versus proprietary right and digital assets, regulatory. As we've already seen, the European Union already recognized that there is a need to regulate some crypto markets and impose certain rules on it, yes, on these particular markets, because they're evolving. They claim sovereignty over, well, piece of crypto markets, however you define it, which is targeted towards European Union as we understand it, and they tell, here are the rules. If you want to play on the, well, on the field of cyber space, which is accessible in the European Union, well, territory, you have to play in accordance to that rules. And this is not the only, you know, field which might develop in the future. Most probably we will see development in different fields as well. And tax was also mentioned. So there are many angles which have to be considered in trying to, well, explain in what way digital assets could be placed in the legal realm and how to deal with them. And when it comes to all these emerging new technologies, well, two main patterns, they are, to a certain extent, they compete to each other, and there might be a different patterns, how we can see the development in the future. So normally, we as lawyers, we are very conservative. We attach to the concept which are embodied in our education, in our training, and we try to conceptualize everything. And if anything new arises, new phenomena, we'll take. Now, this concept matches that. So let's put digital asset in this old concept of 19th century or a different concept. Well, does it match or not? Well, maybe it matches. Okay. Then we can apply patterns and rules in relation to that concept. If we put the digital asset of the specific, well, type of digital assets, and we say it matches this concept of ownership in continental law systems, or at least part of the systems, you are done. You have regulated these particular relationship related to ownership, and maybe that's it. Or maybe, yes, or maybe not, because the particular rules can be drafted in a way that we were dealing not with something digital, virtual, globalized, non-tangible, and you have a problem, then legislator should step in and should tell, no, we need to regulate it. So most probably we will see as well regulatory initiatives evolving in relation to digital assets, which happens. and this might drive a change in the particular realm. One question, should regulators step in advance and tell, here are the rules, and please play by these rules? Most probably not. It's doubtful. Most probably the regulator will lag a little bit behind, and there is a pacing problem, obvious. So, yes, first of all, the patterns will develop, will evolve, and the regulator will step in only when the regulator sees his value of well, issuing certain rules, while protecting somebody or some values, or trying to regulate relationship which becomes chaotic without regulation, or all that stuff. Because all the new regulation might disrupt as well the current realm. And when it comes, necessarily you need to raise awareness of legal community, train lawyers, train judges to be more aware and embrace these coming novelties. Because if they don't, we can see such decisions, as was presented from Dutch pattern, that judges try to stick to the couple of centuries old concepts, trying to define something which is in the 21st century. So in my very concluding remark, well, information or data became an oil of 21st century, as everybody recognized. We need to be aware that this particular phenomena also should be conceptualized in, well, legal realm, put into the different shelves where it is possible. The easiest way is try to a little bit broader conception, try to apply the previous patterns, but not always it is possible. Then the new patterns and new laws will develop, and most probably we will see emergence of that new law. And the advice to the legislators would act very cautiously, trying to protect only adequately what shall be protected, and not to block the innovation, not to block development, and not to block evolution in the particular field. Because if regulator will be too restrictive, innovation will go to the different locations. Escape, for example, European Union bubble, and will settle somewhere else. So that's not most probably our wish as consumers in that particular bubble. Thank you.
Here are preliminary observations for my part. Here you see two worlds. First is virtual world, and second one is our nice old town and our university Renaissance building on the right. And we somehow should join them, yeah? And the instrument for that is private law, which I believe must bridge the gap between those two worlds, and as well as digital, real, and financial economies. But first, we should have comprehensive and good theoretical framework for digital assets. And thank you, colleagues, that you are doing well in that field. So here I will present my ideas, my modest ideas on the topic, and some classifications, some concepts, and some evaluations of what has been done yet. So first, I want to present current legal landscape in Western world. Here you see layer of European Union law, several initiatives on the topic, digital content in consumer contract law, regulation on crypto assets and associated rules in the same digital content directive, anti-money laundering directive. Also, novelty is draft regulation on digital euro, which may change the understanding of not just money, but impact the whole monetary system, as well as proprietary aspects of money. Also, we have layer of European national law, which takes the main charge here, still takes. So we have two systems. First is based on regime in rem, or regime based on property law, and such countries as France, England, and Lithuania present this group of countries, and another is regime in personam, or personal rights. Those are countries which are following Germanic legal tradition and narrow understanding of property objects. Also, there is some movement in United States of America. Article 12 on controllable electronic records, and under, as far as I understand, under American state property law, digital assets are intangible property interest, or right, in other words. Also, we have soft law, and here draft common frame of reference is not very suitable, because it restricts goods in book on property law of movables only to corporeal movables. So it implies regime in personam here. But fortunately, we have UNIDROIT principles on digital assets and private law, where Matthias is co-author. European Law Institute principles on the use of digital assets as security, CF is co-author, and English Law Commission's report on digital assets. It's about 300 pages, very interesting report. Now I will try to make some reflections on the concept of digital assets. And here we have several definitions on that, several different definitions, and all of them, in my opinion, are deficient. All of them have some vices. From my perspective, the most perfect is first, because it addresses at least the elements of value, economic value, which is important for incorporeal property. Otherwise, we will have property everywhere. And also such proprietary terms as possession or control. UNIDROIT principles are not such advanced in that respect, because they present too broad definition. Digital assets, according to them, means an electronic record which is capable of being subject to control. So no reference to value, and also being subject to control. I find that element deficient, because I can control assets physically. Let's say I have my hard disk or phone, and I can put all data I want from one room to another. That will be control. So we should narrow that definition to control in virtual space. That will make sense. That's why I present my definition, with its own vices, of course. But for me, digital assets are digitally recorded valuable objects. Value is of attention and subject to control. That's not abstractly, but in a virtual space. Because, as I said, we can control physically all data, even raw data. There is a classification. I find all digital assets subject to division into broad categories. First is straight or plain or vanilla assets, mostly used outside the financial markets. So pioneers in this field, and which I think attracted the attention of Fairfield, which I guess paved the road for digital property or virtual property in United States legal doctrine. So those I denominate in common as digital identifiers. So domain names, email addresses, social media accounts, avatars, so on. Then comes data files, embodiments of digital content, which I call corpus mechanicum. And they contain video, audio, and other information, which may be protected by another laws, intellectual property laws, personality rights, so on. But data files as embodiments, as corpus mechanicum, they are objects of, or capable to be specific objects of property law. If they can be, which is a matter of fact. Also, objects of metaverse. Metaverse is alternative virtual world, which is combined from different, let's say, different projects where you can, for instance, Decentraland, where you can buy land plots, and the transaction was recorded in that platform, which reached about $1 million for a land plot near the center of that virtual city. So we have prices and real estate, so-called real estate market in metaverse, which resembles prices of real world. Also, second category is crypto assets, mostly used as I think in financial markets. So payment instruments like Bitcoin investment, which may fall under the financial regulation, utility, and NFTs, non-fungible tokens. So objects of metaverse may be crypted, may be just plain assets. Here is presentation and matrix of our property law. The system of our objects in our property law. Two upper rows presents it. First layer is corporeal property, and second one, more important for this presentation, is incorporeal property, or res incorporales, and it may consist of incorporeal movables, even immovable, intangible enterprise, if it is consisted purely from intangible assets. And I find three types of incorporeal property in under Lithuanian property law. First is financial assets, second digital assets, and third patrimonial rights, personal, limited property rights, and IP rights. So we don't have that problem of numerus clausus of legal objects in property law. Instead, we have cumulative criteria of economic value, because object should be at least valuable and at least have some demand to be object of property rights. Also, we should have, that's a rule of thumb, we should have specificity, because we are talking about property rights. And third is control, or corpus in Latin. The effects of the inclusion of digital assets in private law are as follows. In general, if we acknowledge digital assets as property, which may be possessed, used, disposed, and protected, erga omnes or inter partes, it creates effects, all surrounding effects in all private law, such as company law, as a possible element of company capital, individual, common, private, public property regimes in property law, as well as for family law, because spouses may want to divorce and divide their virtual assets. Estate under succession, as colleague presented. Also intellectual property, but relation is only as embodiment or transfer vehicle digital assets as transfer vehicle for intellectual property rights. Also, they may serve as debt collateral, assets for seizure and enforcement, be a freely subject matter of a contract, and also dangerous substances or products invoking strict liability in tort. Because digital assets may be dangerous, hazardous, and in that case, they may attract product liability. In fact, European Commission is working on that field and want to alter the regulation, which would include digital assets. Additional legal implications which are interesting from the doctrine of private law are those which I just selectively wrote down. So let's say I find out in UNIDROIT principles novel form of transfer. Normally, when asset is destructed, property rights are extinguished. And if it recreated, new property rights are created. But here we have a novel form of transfer by destruction and recreation of the same economic asset, but in different, let's say, in different body, technical body. So that would go against classical principles of property law, but still it is economically sound. Also, we may have a question of restitution of burnt coins, but burnt or destroyed coins. The answer under Lithuanian law is very simple because our law of restitution is very flexible. So instead of getting back thing, you may get back equivalent in money, and so on. So since the time is running out, I would like to address the way forward, how I see solutions and inclusion of digital assets into the systems of our private law. Of course, a reasonable system should deal with both aspects, in both proprietary and personal aspects, and the adaptation of legislation, national legislation, or national law, let's say, in broader terms, may go in two directions. First one is legislation. For that, I would suggest that legislator should take time for analysis and draft amendments to the civil code and maybe other laws with the help of academia and technical experts. It may go under the alteration of civil code or enactment of special statute. And second way is through judiciary. Actually, our property law, our civil code, enables us to react in the second way, by judicial precedents. The problem is, but are we able to do that? Because we are struggling with very basic cases of property law here in Lithuania, which the recent example is this case, where courts declared in opposition to our civil code, but we have even no competence to scrutinize case where the lawsuit is for declaration of disputed property rights. So it's very backward legal precedent, but our legal system, our judicial system has approved that. So I'm not very sure about the perspectives for us, for Lithuanians, to reform our private law through that second way, although our civil code may allow us. There is enough flexibility written down in the civil code. And also, I expect that EU legislation may take the initiative here and create, as far as this is still terra incognita, let's say, European instrument for digital property law. So that's all. Thank you.
So I will speak, it's not yet on the screen, but I guess I can start already, about whether it's feasible under the Lithuanian law to use digital assets, at least some of them, as a security in order to secure the performance of the obligation, in order to facilitate new credit, right? So whether it's indeed feasible, does the current Lithuanian law allows us to use digital assets as collateral, which means as the object of, in Lithuania, it's hypotheka and įkeitimas. So hypotheka right and the right of charge. I use the English term of charge for Lithuanian word įkeitimas, which in English for possessory charges, we can also use the term pledge. But just for the English-speaking audience, we'll be speaking about charges, both possessory and non-possessory, which under the Lithuanian Civil Code are called įkeitimas. Okay, let's move forward. So first, the background of Lithuanian security laws, security in rem, hypotheka and charges. Where do we stand at the moment? What are the key features of the law? So over the last 20 years, Lithuanian security law was fully reformed. So there were a couple of waves of reform. It all started in '96, way before the new civil code was enacted. Then it was reformed, further modernized with the enaction of the civil code. And then a very significant wave of reform came in 2012, where I was the drafter, luckily. And I'm very proud of what we did in 2012. And a couple of years ago, there was also some small reform targeting the electronic registration of pledges, e-filing system. So that is also a little bit significant. So we have provisions on security interests codified in the Civil Code. You see it on the screen. There are rules for hypotheks, charges over immovable property, and rules over charges of movables. Again, more than actually 30 articles for charges over movable and almost 30 articles of the Civil Code regarding the hypotheks. We use this Latin expression hypotheca to denote charges over immovable property. So how all those rules were drafted? They were drafted learning heavily from the soft law instruments and also comparative jurisprudence. So really we tried to implement all the good practices on security law into our legal system, into our civil code. So what was very important already initially in '96, it was EBRD model law on secure transaction. Then for the wave of reform in 2012, we relied heavily on UNCITRAL legislative guide on secure transaction. And we used a number of soft law instruments, so Trento project on European private law. So it was Professor Eva Maria Kieninger work. We took note on draft common frame of reference book 9, proprietary security in movable assets. We actually learned a lot about Professor Van Erp, especially as far as his work on numerous clauses or quasi-numerous clauses of proprietary interest are concerned. So it's a fairly modern system. What are key features in concreto? First of all, the scope of assets that can be used as collateral is very broad. There are no specific limitations on type of assets that can be used legally as collateral under the Lithuanian security law. Very broad scope. Both intangible property is clearly, expressly eligible. So here Lithuanian law, in a way, is very practical, but there's nothing new. 2,000 years ago, the Romans, we forget about the Romans often, even in the continental Europe, they have object of property rights called the thing. It's res in Latin, the thing. In medieval Europe and the 19th century, the thing somehow became just the corporeal things that you can touch. But if you read Gaius, he's very clearly speaking about res incorporalis. It was 2,000 years ago. Things you cannot touch. Receivables, usufruct, rights. Of course, the Romans, they did not have virtual reality and digital assets, but they knew one thing. Thing is not only corporeal. So Lithuanian law expressly allows us to charge or to pledge, even to pledge, in corporeal things. Future property. There's no requirement that you can only charge as collateral the property that exists right now. It can be future property. And you can secure both existing obligation and future obligation. Here, the scope is also very broad, right? Now, the principle of specificity, we've heard a lot about the specificity. Specificity is one of the historical monstrosities which creates a number of crazy and totally unjust results as far as property law and disputes involving property law is concerned around the world, especially in cases of insolvency, as we've heard earlier. Crazy results because it's not specific. So at least as far as Lithuanian current security law is concerned, we don't have the traditional principle of specificity applicable to a collateral. We allow to charge as collateral unspecified pool of assets. What is specific, it's the pool of assets. So basically what we have universal business charges. So in English law, those who are familiar with English law, you have floating charge, right? And some of you might be familiar with Professor Wood. So what you deal as the object. The object is the pool of assets. What's inside the pool can change from time to time in the ordinary course of business. Like, for example, you can charge a river. The pool starts at the Green Bridge in Vilnius and ends at whatever bridge you choose, the White Bridge or Žvėryno Bridge. So the water between those bridges, what happens with the water, friends? It changes, right? The water flows. The water flows. But you can charge this object as collateral under existing Lithuanian law, no problem. There are two ways how to charge this, but I don't have time to go into detail. Įmonės hipoteka, enterprise hipoteka, or charge of movables based on Article 202, Book 4. Now, the creation of security interest, both possessory and non-possessory, is very quick and cheap. For non-possessory interest, you go to the notary public, and notary does the filing in the public registry. For possessory interest, you don't even need to go to the notary. The written contract suffices, and written does not necessarily mean traditionally wet ink written, right? And it's perfected by possession, but you can still file it in order to create voluntarily notice filing-based extra layer of security, extra layer of perfection to be sure that you can enforce it erga omnes. This we call perfection, right? Which is one of the central concepts in security law. Perfection is the sort of English law-based word. In the continental Europe, we are more likely to use the word how to make security interest enforceable against third parties. So to give a security interest erga omnes effect, which is the essence of security interest. It's very easy to create a right between the parties, inter-parties right? But what you want to do with your security, you want it to be effective against the world at large, erga omnes effect. So in Lithuania, as I've said, very modern registration system as the main tool to perfect security interest, or you can take possession. Or you can take possession as the alternative. So either possession or registration. Now, speaking about possession, which as we'll see later on, or we've heard already, is very important for the digital assets. Possession in Lithuania is also understood as symbolic possession, which means you don't need necessarily to possess a thing. You can control a thing. Symbolic possession is same thing, just different legal terms as control. So it's already there. You can take symbolic possession and you can perfect security interest by symbolic possession. For example, if the collateral is securities, intangible securities, not security, but securities, stocks, how I take symbolic possession as the secured creditor in stocks? It's very easy. I make an inscription in my securities account, and the same inscription is made in debtor securities account that these stocks are charged and I'm the security right holder. Symbolic possession. Enforcement. Lithuania is very proud of having very efficient enforcement out of courts of both possessory and non-possessory charges. How do we do it? We go to the notary, and notary makes the execution order. And it's a very limited possibility to challenge for the debtor that order before the court. So it's very cheap and very quick. We are one of the few jurisdictions in the world where not only the security interest is created in a very fast, expedient, and cheap manner, but when it comes to enforcement, you don't need to go to court and prove your case. It is out-of-court enforcement for all types of security interest right now. Another thing, foreclosure by taking ownership is allowed. So what in Roman times was called, I'm sure you know it, pacta commissoria. It's still something many civil law jurisdictions have problem with. Creditor is not allowed to take the ownership. You need to sell it somehow, very often from the public auction, very often involving the bailiff, which makes it very cumbersome and is very unsuitable for digital assets, by the way. We allow to take ownership. Pacta commissoria is already allowed. So in German, for example, you know, they have a very clumsy traditional system of security interest. That is why they invented, via the court, Sicherungsübereignung, which is ownership-based security. You transfer ownership for security purposes, but this is not Pfandrecht, it's something different. And then blah, 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 all those crazy legal problems, what to do and whether it is recognizable, for example, in the Netherlands. Probably not, but it's another story. Now, priority. Lithuanian law, and it's a final feature of Lithuanian security law right now, recognizes the so-called super priority of security right, both hypotheca and įkeitimas, over all other competing interests. So, secured creditor is not subordinated by law to any other creditor, and it doesn't even stop there. This super priority survives the insolvency of the debtor. There's no subordination in case of insolvency. So Lithuanian security law system is super credit oriented, very cheap, very modern, but it has zero language, as far as the statute is concerned, about digital assets. So what would be your educated guess? Can we charge as collateral digital assets today in Lithuania under the present regime? The answer is obvious. We've heard Laurynas. Of course we can. Of course we can. At least some classes of digital assets, because we already know, right, that the digital asset is the very broad world, and some of the assets that are digital assets, probably there is still a very significant dispute whether they fall within the scope of object of propriety right, even in Lithuania. But those digital assets, as in Laurynas' presentation, that are basically cryptocurrencies, all the Bitcoin-based structures, NFTs, all those digital animals, digital assets, can definitely be used as collateral in Lithuania. And the perfection, the ergo omnes effect of a charge to such an asset can be achieved in two ways. So it's either registration in the public registry for non-possessory instrument, or taking the symbolic control. So we can also use possessory charge. And in addition to the possession, it is also possible to do the notice filing to contracts registry, sutarčių registras, to give voluntarily additional perfection, although taking possession is enough in itself. Is it the full story? What do you think? Of course it's not, otherwise I won't pose this question. There are problematic aspects. And those problematic aspects are obvious. It's difficult to specify digital asset. It's difficult to identify digital asset. It's difficult to specify in what jurisdiction this digital asset is actually located. So this is Rimantas' presentation. All those problems, of course, are there as well. The solution is, of course, to use floating charge as the option, which helps a lot, but still, look at the doggy, by the way, isn't it lovely? It doesn't help to cope with extraterritorial problematic, which comes with the digital assets. So the resume is this. Esteemed audience, my friends, Lithuanian law definitely allows already today to charge, to use as collateral digital assets to create such a charge, but it is very problematic to enforce it, especially when the debtor is out of the jurisdiction, when the exchange is out of the jurisdiction, or when the collateral is transferred to a third party, which will very often claim to be a bona fide third party, bona fide acquirer. So what to do? And I'm finalizing. There were solutions like UCC Article 9, very recent revision. UCC is Uniform Commercial Code of the United States, which more tackled the perfection issues. Because in many jurisdictions, this enough is problematic. In Lithuania, we don't have the issues with perfection. Then there are international solutions like those lovely, very recent UNIDROIT principles on digital assets, where security interests on digital assets are addressed. The main principle is that you can create charge over the digital assets in the UNIDROIT principle. And the main perfection instrument is control under the UNIDROIT principle. But the solution could be to go one step further. There is a very nice precedent, another UNIDROIT instrument, Cape Town Convention 2001, on security interest in mobile equipment. And at least as far as it is concerned with the protocol on airplanes, it is a very successful instrument. So to continue UNIDROIT's work from principle to convention, I think is the way forward. Thank you so much.
Last but not the least, as our presentation. Enforcement procedures as the final stage of the civil process is surprisingly rooted in the pure law theory, which is concerned, among other things, with the fundamental definitions of the subject of the law. Because without a definition, it is really hard or even impossible to have a valid procedure. Without having a clear definition, you can, in principle, to develop a system of logically valid and consistent procedures. But only having a clear definition, you can complete such a system into the law. With more usual physical assets, there's no ambiguity in interpretation of the asset from different perspectives. Meaning that car is a car. It is asset for the producer, for the owner, and for the bailiff. With a digital asset, it is the perspective what makes or denies it being a digital asset. For example, electronic book is an asset for the publisher and the author. It is also asset to the buyer of the electronic book, and I specifically emphasize buyer, not the owner, because you might not necessarily be allowed to borrow your electronic book to a friend, for example, subject to the license restrictions. Even more so, it's probably not an asset at all to the bailiff, especially if it is attached to the electronic identity of a buyer, which is definitely not a subject of enforcement. And with the current licensing laws, not detachable in any meaningful ways. Effective enforcement in the digital era. What could we say about it? A person who wants to defend his or her violated rights does not need a court decision which only declares their violation or only a discovery of this violation, but they need a real defense of rights. This can only be ensured by an effective system of enforcement of court decision. The aim of making the enforcement process more efficient and adaptable to changing circumstances is by globalization and digitalization is the task of the entire legal community. In response to the regulatory vacuum of the enforcement process, various international organizations have initiated research, and one of the main initiatives in the adoption of the adoption is the Global Digital Enforcement Process Code by the International Union of Bailiffs and Judicial Officers. So we can call it a roadmap. Considering that digitalization has become a global phenomenon affecting essentially all human activities, the Code of Digital Enforcement has designed to define principles applicable in the digital enforcement process. Thus, the code is not legally binding, but it primarily serves an advocacy function to promote awareness and digital understanding among the legal community worldwide, and suggests that it could become a basic for both national and international regulation on the digital enforcement process. The authors of the code encourage the code to become a source of inspiration for national and international legislators and invite all entities involved in the enforcement process to refer to this guide of a good practice. And now, my colleague Kristina will continue our presentation and delve into the deep analysis of enforcement procedure.
So, hello, dear colleagues. I'm very happy to speak to you here today. And we are talking about challenges, and are they really advantages or are they disadvantages? From one perspective, they might be very attractive, and the pseudonymity, anonymity aspects, private individuals like those digital assets because of those features. But we face many difficulties. So hardness to evaluate the value of digital assets is one of the most challenging aspects. As you probably all have read through the websites, NFTs now are almost worthless, as all they say. And it was January 2022, then non-fungible tokens were all the rage. And probably you know the famous pop star Justin Bieber. He bought an NFT Bored Ape for $1.3 million. That's pretty a sum of money. Fast forward after 18 months, it's now one of Bieber's biggest regrets, as this NFT costs only about 60,000 today, and the net loss is about 1,024,000. So imagine if you were one of Justin Bieber's creditors and he would not have any other property. It could be very sad. And another risks are related to the ownership rights. And ownership rights may be subject to considerations, to legal considerations. Ownership rights related to digital assets, they can be very complex, and infringement of them might be a significant concern. So it can be really, really challenging to enforce proper intellectual property rights in the digital realm if they are contested. To overcome these issues, we need some clear governance frameworks, and also maybe we could think about some dispute resolution methods, which are most probably required. Dependency mostly on technology is another very challenging issue of digital assets, and if you face difficulties with access to digital device, or if information saved in those means is broken for somehow, it might be lost forever. Therefore, we suggest that bailiffs should not rely solely on material storage devices, but they should use cloud technologies while saving the information. Cybersecurity risks. Of course, cybersecurity is very important as more as privacy concerns, and it is a very challenging issue because such risks, they reside in online environments. Information might be very sensitive, and a wide range of cyber threats such as malware, phishing attacks, ransomware, various types of hacking attempts might make it broken. Cyber criminals, they usually develop more sophisticated techniques and tools to compromise those popular digital assets, and they can contain sensitive information about individuals or organizations. So data breach can result in the exposure of this information, leading to identity theft, to financial fraud, other forms of cybercrime. This can enhance severe financial, legal, reputational consequences for the affected parties. As users want assurance that their personal information is being handled securely and in compliance with privacy laws, so bailiffs should be well aware of that, because failure to do so, to secure the information, can result not only reputational damages, but also very serious legal consequences. So given these challenges, it's crucial to prioritize cybersecurity, privacy measures, include some robust security protocols, conduct regular audits, provide training, staying informed about latest good practices, sharing thoughts with international colleagues. Such conferences like we have today, it's very good also opportunity to share perspectives from different countries. Well, what about issues while enforcement from digital assets? Is it possible? Now it's not, but maybe we will have it in some 5 years, I think. As a colleague Andrius told, it's very, very possible to include those guarantees, like for transactions, for contracts, but how to enforce them if they are, for example, anonymous. The person finds digital assets attractive due to their anonymity and pseudonymity, but conducting transactions or activities without revealing one's true identity might suggest very big problems. And the recovery process might become particularly difficult, even if we have a judgment awarding one or another digital asset. It doesn't mean that we can easily take it from that person. Jurisdictional issues were already discussed, and so on. So what do we suggest? Nothing very revolutionary. I suggest establishing and clarifying the regulation, starting perhaps from good practices, as my colleague Rimantas mentioned in his presentation. So we must try to enhance as much as we can international cooperation, of course. And we could also develop and implement and develop advanced technologies for tracking and identifying users involved in digital assets transactions. In this way, increasing transparency in such transactions. What about Lithuania? Are we digitally ready for those for those suggested procedures, for those regulations. Well, I should say that the Chamber of Bailiffs of Lithuania, they initiate and promote a lot of modern technologies, prospects for the digitalization of the activities of bailiffs. And talking about, for example, Article 624 prim of the Code of our Civil Procedure, it regulates the peculiarities of using the information and electronic and communication technologies in the enforcement process. Also, we have Article 431 prim of the law on bailiffs. It determines the use of electronic executive files, information, electronic communication technologies, and activities of bailiffs. Absolutely normal is to use electronic signatures, electronic files, electronic documents. So I should say that Lithuania is ready for further changes, and I think they are coming really soon. How to enforce? First of all, of course, as I told, legal framework and legislation is needed. Another thing is centralized registry, and this should be made public to all the bailiffs, but I should say that individuals might then search for another jurisdiction which is more pro-user friendly. Over time, individuals will be more inclined in investing and using digital assets. So as long as we are not ready to regulate and register, creditors cannot feel very safe, I should say. And digital assets should not become a tool to debtors to hide their real property. So to sum up, the efficiency in the enforcement process may be considered as a cornerstone element, which allows us to maintain justice and order in society. That is our goal. And Lithuania is ready for that. The enforcement process is advanced and modern due to already implemented digital technologies. And delving into the digital enforcement process, we can deal with the issue of recovery from digital assets and the digitalization of enforcement process actions. Of course, communication, proper training, and sharing good practices would be very, very good thing. So thank you for your time, and we'll wait for your questions.